Karen Moore, what's on your mind this week?
Well, even though I'm trying to keep a really broad eye on a whole number of things, I keep getting caught out by surprise. So, what's on my mind is the somewhat unexpected April 7th proposal by Republican Representative Kathy Rogers and Democrat Senator Maria Cantwell proposing an American Privacy Rights Act. So, we've got both a bipartisan and bicameral proposal. It's early days, but it seems to have gotten some pretty good traction in legislative discussions mid-April. So we'll see. So I wanted to try and get a little ahead of the curve and take a look at the complexities of this proposal, many of which I'm sure will change, but particularly as they relate to artificial intelligence. And I'm going to start with what I think is kind of a fun one, which is part of the preemption clause. The current draft does contain a preemption clause that says this is going to be a federal law and state laws are no longer going to apply, which California, among others, is obviously not happy about. So we might see some further dilution of that. They're already a set of listed. The AI related one that I like, which seems bizarrely specific, is that the preemption clause would not preclude actions pursued under state criminal laws. That I wrote the language down here, that intimate images, including authentic or generated by a computer or by artificial intelligence known to be consensual, would not be superseded by the act. So I guess if there are any naughty images that have been generated by a that involve your personal rights somehow, that could still be pursued under state criminal laws. I kind of like that that was one of the two really specific AI references in the entirety of the act. Okay. The bigger one that specifically referenced pertains to automated decision making, which will then implicate changes potentially to all of the way a lot of companies are operating. The automated decision making provisions define covered algorithms, which include those that have been created by or with the involvement of AI, and which make decisions with or without human intervention, which I know is a big part of some of the privacy laws, and particularly one of the key bugbears in the EU. But if they're used to make a determination regarding the provision of services or products or ranking, I have the language here: ordering, promoting, recommending, amplifying, or similarly determining the delivery or display of information to an individual, there are a whole bunch of requirements that are then imposed. And because automated decision making is starting to become a really common use by a large range of operations with a company, and I think Jonathan Armstrong already referred to this in the context of the AI Act in the EU, is that there are a lot of parts of the organization that aren't even aware that they're using automated decision making. So trying to collect those all in and then deciding how we're going to make sure that we're complying if this remains as is with the APRA will be interesting, because if you are using any covered algorithm, which is pretty broadly defined, the developers, first of all, have to conduct a design evaluation prior to the release of the algorithm. And then the companies who are using that algorithm have to provide a notice that algorithm is being used. And most importantly, I think, and difficult to manage, an opportunity for the individual to opt out of the use of that algorithm. Now, that is limited to what are called consequential decisions. And those are decisions, there's kind of a heavy civil rights, human rights element to that, because those consequential decisions are decisions relating to the access to equal employment, housing, employment, education, enrollment, healthcare, insurance, credit, et cetera. So it will be somewhat limited, but managing an opt out, I'm going to say, is akin to managing the data subject access requests, that you're going to have this kind of complexity of how are you actually going to organize that, and maybe need to even use an AI model in order to manage the notice and opt out itself. And then I think equally importantly and potentially somewhat burdensome is the obligation, if you're using one of these covered algorithms, to conduct an impact assessment, which we're seeing more and more often in different contexts, especially in privacy laws. That impact assessment would, in the AI context, need to provide a pretty detailed description of the design process, the methodology, contain a statement of purpose, a description of the data used to train the model, which is maybe more or less foreign, but the decision making process itself, from my understanding, tends to be somewhat part of a black box and very hard. The explainability component can be really difficult. And then the people that are using these kind of algorithms also have to demonstrate the steps that they're taking to prevent harm to minors, which is a pretty big focus of the draft law generally, bias and access to needs like, again, housing, education, or public accommodation. So that automated decision making component, I think, is a really big one. It's going to be interesting to see how that survives various iterations of this draft. And then we've got two carved out groups in the APRA with a slightly elevated level of accountability or responsibility. One really not, well, both really not surprising. One being high impact social media companies. Those are defined as companies that provide internet based services that individuals use in individual or user shared content. You have to have more than 300 million individuals monthly and more than 3 billion in global annual revenue. So I guess we can identify who these high impact social media companies are. In those cases, the browsing data is automatically classified as sensitive data or sensitive information, which is going to impact its use in modeling and also transfer and use by data brokers. So there's another kind of AI implication there. And then the second carved out group are what is identified as large data holders. Loosely, those are entities with annual revenues in excess of 250 million and that are processing the information of more than 5 million individuals. So you can see some pretty large companies are going to get caught up in that. There's a kind of elevated impact assessment on the algorithms that is implicated there. If those algorithms pose a consequential risk of harm to the individual, I could see a lot of healthcare companies and providers there. And there's some increased transparency obligations. So again, just things that need to be moved on. And then the third kind of really large bucket that touches on artificial intelligence in the APRA. It doesn't specifically mention it, but there are data minimization requirements. Those data minimization requirements are not unusual to anybody working with GDPR. They're kind of common principles that are already seen in both the GDPR, CPRA, and others. So data minimization is important, but this is kind of a blanket one. Data minimization really informs the least amount of information needed to accomplish a stated purpose. So you're supposed to now limit the information that you're collecting. I don't know about you, but it feels like these days, if I'm even buying theater tickets online, they're asking for my blood type and all sorts of other information completely unnecessary to my forking over a huge amount of cash for the opportunity to see Ray Fiennes perform Macbeth, which we had the privilege of doing last week. So that was kind of nice. But signing up for supermarket loyalty programs, it just becomes kind of excessive. So the data minimization principles do make sense, but they do have potential, arguably negative consequences for artificial intelligence. Developers who are creating and training models need robust and pretty significant data. So the more you minimize the data, arguably, the more difficult it is to come up with data sets that can accomplish what they need to accomplish. The responses to that have been to use anonymized or aggregated data sets so you can still minimize the data or minimize the impact. You can locally host some of the language modeling that's being used so that it's not being aggregated specifically. So there are all sorts of technical solutions to data minimization and AI models, but it's arguably difficult or makes AI development and use of data sets more problematic. Potentially, I've seen some interesting commentary coming out of the EU, potentially creating more biased data sets because the data is limited. So I don't know. The tension between data minimization and AI is not new, or it's not brand new, at least raised by this. It's something that's been grappled with in the EU for a while, with GDPR throwing up all sorts of challenges. That tension between data minimization and creating robust data sets for AI usage has been around for a while. I've got a couple of really interesting articles. Tom, I can provide you if you want to stick the links up on the site. There's some interesting IBM research out of Haifa University, and there was also a pretty good comprehensive with examples article by Sarah Goldberg at IAPT, or shoot me an email and I can send them. So where we are on this is still very early days. Implications for AI are there. All we have, as usual, the EU is taking the lead here. All we have in the US right now is really comprehensively an executive order regarding AI, which says that privacy has got to be paramount if we're developing AI legislation. So it remains to be seen what the AI implications of the APRA will be, or how the APRA will progress, if it will progress. I'm hoping it will progress, because even an imperfect federal data privacy law is going to be better than 50 state different direction privacy laws, but we'll see where it goes. I mean, a couple of things. One is I am a bad predictor because I made all sorts of noise about the CS when it was first came out. And then I months later predicted its demise as Germany and Italy were strongly opposing it, only for it to come back to life really quickly. So who knows how quickly this may or may not pass through the process. I will note that the current draft only provides 180 days to implement implementation. So starting to think about this now isn't a bad thing, especially if you aren't already looking at the EU AI Act and GDPR. If those don't apply to you, you might want to start taking a look at this. If you're already looking at GDPR and the EU AI Act, you're probably way ahead of the curve already, depending on where we go with the APRA. So we'll see. The two need to work in tandem, but the concept of comprehensive and integrated data governance for large corporations, I think, is becoming more and more important. We can't leave this all to the compliance officer to address. That's where we are.